Let me just admit a few more. This waiting in the lobby is quite funny. All right. We seem to have 35 on. I'm going to proceed. I don't want to keep you any longer. Good evening, Judge. Thanks for joining us. And thank you for making the time.
Felicia.
And as we discussed earlier, you and I are not a fan of long accolades in introducing people. I always find it quite amusing when someone says, you know, this person needs no introduction, and then proceeds to extol all of their many accolades. I believe with you that is indeed, you need no introduction, especially to this forum. But I will say that you are currently an inspecting judge of prisons and the chancellor of Stellenbosch University. And when I'd asked you to talk to what's keeping you busy, you pointed to, well, the very thing you're about to talk to us about. So without holding you up any longer, I thank you for making the time for our organization. I am the outgoing president of AdJASA, but newly appointed vice president, and Hugh Corder is the newly elected president as of 10 minutes ago. I will tell the floor as well as what I told you. I'm going to have to drop off a little while, in a little while, so Hugh will probably chair the question and answer stage of this if I'm still on. For the rest of you, it's the call of the 10-month-old that is dragging me away from Judge's address. Unfortunately, that will have to take precedence here. Well, thank you, and over to you.
Thank you so much, Felicia, and thank you to you and your colleagues. I have previously indicated to you that I thoroughly support the primacy given to your 10-month-old in every way. And Felicia, by way of introduction, may I say that I'm really very pleased to be talking to the AdJASA. A lawyer whom I greatly admire and respect told me that a colleague of mine some years ago had addressed AdJASA's AGM, and he described that person's address as being, quote, incomprehensible nonsense and utter drivel. And I don't say this to denigrate a colleague. I say it for the following reason. My response to the lawyer who relayed this to me was that that particular speaker was neither enamored of nor in terror of Professor Cora Elizabeth Hoekstra, whom I believe is one of the founders of this place. I am both enamored and in terror, and from both those motives, I have given a lot of thought to what I want to say, and I've also prepared very thoroughly. And I can say to you that I'm confident that I'm going to give an interesting and provocative address. So I've chosen the subject, as you've indicated, Felicia, of prisons. This is not only because I have been the inspecting judge of prisons for the last 14 months since the 1st of January last year, when President Ramaphosa appointed me. It's also because the very concept of prisons is arrestingly forbidding, even alarming, and rightly so. Mass confinement of mostly adult males is a relatively recent phenomenon. Earlier, people used outlawing or executions. From 1788 to 1968, about 162,000 persons convicted of often trivial offences in England and Wales and Scotland were transported from Britain to Australia. They literally thought that they were going to export their problem of crime. And in the same way, we think today that we are going to do away with our problem of crime through mass incarceration. It is a terrible mistake. It has overtones of horror, mass incarceration, which future generations may look back on with moral censure, as we do today with apartheid and to Nazism. And I also believe that future generations will look at the way that we produce animal flesh through industrial processes under conditions of extraordinary and excruciating cruelty with the same kind of horror. There's an additional concern in South Africa that as under apartheid, our prisons are becoming dark, closed, and punitive institutions. So our prisons and our prisons practice urgently need attention from public interest lawyers and academics. And why do we turn our gaze away from prisons? And why does the institution of prison still exist? There are some compelling reasons, and I want to give 4. The first is what I call the Hannibal Lecter phenomenon. Some human beings are seriously dangerous. You may call them evil depending on your moral framework, but they inflict terrible destruction. They have to be incarcerated and kept away from society. This fact I regard as elemental and inescapable. A second reason is that we all have a genuine fear of crime, a dread of how violent and other intrusions on our life interests may damage what is precious to us. South Africa has one of the highest rates of violent crime in the world, particularly anti-women violent crime called gender-based violence. Our murder rate has gone up since 2012. It's about 35.8 per 100,000. That means that today, 58 people were murdered. And each of us has real and legitimate reason to be apprehensive. As inspecting judge of prisons on a judicial pension, protected by my status, the location of my residence, my mobility, even my whiteness, I must humble myself before the rage and fear that my fellow South Africans rightly feel about violent crime. My third reason is related to that crime is highly politicized in South Africa. It is an issue of both race and class. This is a cruel and sad juxtaposition when it comes to seeing how the criminal justice system has so far treated those accused of grotesque acts of public thievery and corruption, and those accused of petty and serious crimes. They experience the wrath of our criminal laws and the byproduct of a broken prison system as a further punishment. It seems that poverty and blackness often mean a matching voicelessness. The last and fourth reason why prisons continue to operate and why we really face a conceptual dilemma about imprisonment and incarceration is that if the societies of institutions of governance do too little about crime, people will resort to vengeance themselves. That is what is happening in South Africa. As corruption and institutional dysfunction have eaten away at our administrative justice institutions, vigilantism has become a crisis. Last year, in the last statistical year alone, vigilantism was a causative factor in 1,202 murders, 3 every day. That is a staggering figure. So all of those reasons mean that until we have deeper insight, deeper practical measures, and deeper alternatives, prisons are going to remain with us, and hence my selection of my choice with which to challenge you tonight. Let me tell you what I'm going to do. I'm going to hope to provoke the debate. I'm going to speak about the history of prisons in South Africa, our aspirations after the world's most famous prisoner, Nelson Mandela, became our first democratic president under a wonderful constitution. And I'm going to speak about the grim and grimy reality that has occurred in our prisons practice. And then I'm going to conclude in the main section of my lecture with a series of 3 big challenges to you as administrative lawyers, challenges on segregation, on bail, and other conditions of confinement, which I shall spell out. So let me skip the most of the largest of the next section, which is the introduction of prisons at the Cape with the white colonial settlement in 1652, particularly on Robben Island, the British occupation, which introduced institutionalized imprisonment. The white colonists, both Boer and British, resisted the transportation which was being practiced to Australia, and therefore convicts from the UK did not come to the Cape. But with the abolition of the slave trade, prisons became a source of unskilled black labor at the Cape and later for the mines. The Lansdowne Commission of 1945 spoke about the cruel and discriminatory prison system and remarked on the incarceration without prospect of rehabilitation for black inmates. What came of the Lansdowne Commission's report of 1945? Nothing, partly because 3 years later, the hard right, white supremacist apartheid government was elected. And during apartheid, prisons became a key site of apartheid enforcement. Black men were increasingly incarcerated for past laws and for failing to pay taxes. It became clear that the South African penal system was used to control perceived threats to white supremacism and to the morals and the well-beings of the Afrikaner nationalist state. Sex work, drug use, expressions of sexuality. Prisons also became closed institutions. Media and outside inspections were prohibited, and the reporting and publishing of photographs became very difficult, which created what was called, in the white paper, a closed institutional culture within the prison service. And of course, prisons were used to control political dissent, to quell it. Political prisoners' reading matter was even strictly controlled. And most shamefully, apart from use to control mass political unrest, was the use of prisons for enforcing apartheid through the past laws. Listen to this figure. It's one that shocked me even though I sat in past courts in the 1970s and 80s. Between 1975 and 1984, 1.9 million people, black people who belong in this country, whose indigenous roots on this country, were arrested for being in the wrong place, for failing to carry documents, for being in what is called an unauthorized location. Let us not forget this 27 years after the formal end of apartheid. So now I'm starting my challenge to you, dear colleagues. I'm talking about what administrative lawyers did under apartheid. I'm not vainglorious, but I am proud to say that at the Center for Applied Legal Studies, in association with Lawyers for Human Rights, the Legal Resources Center, and many, many private lawyers, after Gilbert Marcus, for example, left Kells, he did a lot of administrative law work. Prison authorities under apartheid had very wide discretion. Ouster clauses excluded legal oversight. Detention without trial was widely used, both in the 1950s, but especially from the Internal Security Act and the Terrorism Act. They strategically challenged the apartheid laws through their very open texture. In some rare instances, this actually alleviated the harsh impact of apartheid laws. And this was why Dugard and Murenik urged that just judges should remain on the bench and not resign. But the role of administrative law is captured by the object of my terror and enamorment, Professor Elizabeth Cora Hoekstra, who noted that the grounds of review under apartheid in administrative law had to be made to function as a miniature Bill of Rights. So the role of administrative justice lawyers and administrative principles in vindicating basic rights of those incarcerated under apartheid is something that I want to hold up to us tonight as an inspiration, a reminder, and an example. Now we come to harsh reality. Prisons in post-apartheid South Africa, lofty aspirations, dignity, restorative justice, a culture of justification. We embraced a restorative approach under President Mandela. The Constitution's founding values, human dignity. Section 35, which was based on what had gone before, includes a right to conditions of detention that are consistent with human dignity, adequate accommodation, nutrition, reading material after Corbett lost, Corbett was in the minority in the Mandela challenge to the prohibition of reading material for political prisoners. And then the right to just administrative action afforded to everyone, including prisoners, enshrined in Section 33. Murenik envisaged that the Bill of Rights was our chief strut, and that this particular right of administrative justice, which is your concern, would spearhead, his words, spearhead the effort to bring about a culture of justification as a break from apartheid's culture of authority. And PADJA does this. Its preamble states that its purpose is to create a culture of accountability, openness, and transparency. The first hearing in the new Constitutional Court, which was later in 2004, constructed deliberately on top of and inside the foundations of number 4 and 5, the apartheid era famous, infamous pass law prison on Constitutional Hill in South Africa. On 15th of February 1995, at its first sitting, the court heard a challenge to the death penalty and struck it down later in Makwanyane. So against this background, the white papers on corrections, 1994 and 2004, said that imprisonment should be used to nurture and rebuild relationships between the offender, the community, and society at large. And this is the statute we still have. It's a beautiful Mandela-era statute. The last case that I delivered judgment on before I retired from the court, on the day I stepped down, was another Mandela-era statute, the Labour Tenants Act, another beautiful, simple act crafted while Jeff Budlander was the Director General of Land Affairs under Mandela. Simplicity, clarity, and forward-looking ideals. Prisoners became inmates. Prisons became correctional centre. Corrections were defined as aimed at correcting the offending behaviour of sentenced offenders in order to rehabilitate them. And critically, coming to my role, the Act pierced the closed institutional culture. One can even read the Act as a credit to Murenik, who had spoken about this culture of justification, and tragically 2 years before the Act's enactment took his own life in despair at various happenings. So the Act required the opening of the closed institutional culture by requiring the establishment of an independent judicial correctorate, so independent inspectorate of correctional services, which was tasked with monitoring, inspecting, and reporting on the conditions in prisons and the treatment of detained and incarcerated persons. Thus, the lofty aspirations, now to grim reality. Summary: we over-incarcerate in often appalling conditions. We faced what was called a post-apartheid crime wave. What our legislators ignored was that actually from about 1998 until 2011, the crime wave came down. In 2011, there were half the numbers of murders, nearly half, 16,000 murders, compared to 1994 when there were 29,000. So the crime wave was a bit of a chimera, but it required political action, and the politicians, the political elite, talk of all of us. Don't point fingers, ladies and gentlemen, friends, colleagues. Talk about ourselves as part of this political elite, because we are beneficiaries of it. The halcyon interlude was broken when the enactment of some of the most vicious, repressive sentencing and criminal legislation anywhere. We took our template from Michigan and other states. It was also being done by the Blair government in the UK. Very similar things are being done, but at least in the United States and in the UK, they are stepping back from this harsh, lock them up and throw away the key approach. Part of my objective tonight is to provoke debate, because that debate has not yet occurred in South Africa. So what happened? Minimum sentences, terrible minimum sentences, imposed even for non-violent crimes, drugs and drug-related non-violent offences. The war on drugs, 1 century old, started in the early 1920s, the most gigantic public policy mistake of the last 100 years, has wrecked the political systems and criminal justice systems of South and Central America, and has wrecked the public morality of the United States itself. Bail and parole processes were stiffened. It was sold to the public as what was called a temporary solution to a temporary problem. But even as the murder rate halved towards the end of the 2010s, all of these remained in force 3/4 of a century later. So apartheid's institutional structures, both physical and of mind, a deeply entrenched militaristic culture, and approaches to incarceration in bureaucratic and public attitudes became entrenched. Today, we have the highest prison population in Africa and the 12th highest in the world. The number of incarcerated persons has increased under democracy by 1/4. The remand population constitutes 1/3 of that total. Most appallingly, and I'll come to this later when I offer you the challenge of parole, is life sentence, those under life sentence, lifers. In 1995, 400. Today, 16,856. And the challenge I'm going to throw at you in about 10 minutes is that the only person who can give final say on parole for all of these is the Minister of Justice and Correctional Services himself. So there's a terrible bottleneck. We have jam-packed our jails with people under life sentence. And what has it done to the crime wave? It hasn't helped. Our crime wave is going up again. We need to radically rethink the terrible misprescriptions that we've undertaken with this problem. And overcrowding has led to inhumane, degrading conditions of detention. All of these problems were exposed by the Jolly Commission 15, 16, 17 years ago. Intra-institutionally, unhygienic conditions, sexual violence, general violence, the risk of transmitting communicable and infectious diseases, mental health, dilapidated and decayed infrastructure, extra-institutionally, where degradation and violation of basic rights seeps into the community and is embodied in post-release experiences. And of course, overcrowding thwarts good governance administration. Not just is there a terrible cost in this horrific sustained mistake that we are making in our beautiful democracy, but there's a cost also to the taxpayer. On the latest DCS budget, the daily cost per prisoner is 447 Rand. It costs us 163,000 Rand per year to keep every prisoner. And it's no solution, as I've already said. And of course, COVID has cast a harsh light on all of this. It's been known since the early 18th century, where the earliest prisons were described by pioneering public health doctors, that deadly contagion spreads dangerously in prisons, putting inmates, personnel, and their surrounding communities at danger. A recent paper in The Lancet describes how important it is that there should be alleviative releases, urgent alleviative releases in the COVID conditions. And President Ramaphosa, to his credit, on the 8th of May last year, authorized a special dispensation for 19,000 non-violent offenders to bring forward their parole. And the impact has been very beneficial. The most recent statistics indicate that the total prison population has gone down from 154,000 to 147,000. But listen to the proportion. The proportion of remand detainees has gone up from its 40,000 and 92,289 sentenced offenders. And of course, the COVID releases put forth a more profound question. If we're going to release all these people, why were they in prison in the first place? I might intersperse very quickly that, to my grief, I was unable to persuade the Minister of Justice, who's an able and attentive and aggressively minded advocate and lawyer himself, to use his powers under the emergency COVID regulations to order a mass release of the category that I'll come to soon, which is those prisoners who were granted bail by the court but were unable to pay it. And I'll come back to that in a moment. So we have strange bedfellows. We have a prison system which departs from the aspirational, lofty values of the statute, and we've got JICS, which has got reporting obligations. And the dysfunction is illustrated through mandatory reporting, where the Prisons Department is required to report every death, natural or unnatural, every use of force, and every time an inmate is put in solitary confinement, and every time that an inmate is put in mechanical restraints. Those four categories of mandatory reporting are absolutely required by the Act, and yet there's been a grievous fall down in mandatory reporting preceding COVID. The previous reporting system, online reporting system, became dysfunctional. Mr. Mekwe, the senior IT person in the National Commissioner's Office, has got a new e-corrections service going, the e-corrections system. But of course, it can't undo the lost years where we don't know what was happening when the statute wasn't being fulfilled. So also the question of AdJASA's independence. There are many questions which arise from the Constitutional Court's judgment, upholding the main substance of Judge Bukwanya's judgment in the Cape High Court from 2018, and striking down the provisions in the Correctional Service Act that rendered AdJASA insufficiently independent. So the question for me really is, how will enhancement of our independence as an inspectorate enhance our capacity to do our job within this system? What challenges will we face? Will there be budget cuts? Do we have to overcome a lack of political will in our reports and recommendations? And how can a watchdog institution meaningfully survive with insufficient practical bite? And that brings me to the next section of my talk. Before those three challenges that I'm going to come back to before concluding, I've got my eye on the clock because I want to leave time for questions. AdJASA's relative powerlessness makes me ask a question, which is, what good do prisons inspectorates do? First, there are two features of the legislation. First, we have no operational, managerial, or executive power over DCS's operations. We can't tell them how to run their parole system, where to put extra ablutions in, how to run their kitchens, who to transfer, who to discipline. We've got no power over the operations of DCS. Secondly, DCS has no statutory-based obligation to account to AdJASA, to implement its recommendations and findings, or even to respond on them. We have a good relationship with DCS, and they've undertaken to implement our findings and recommendations, but it's not rooted in the statute. And there's the troubling question. Michel Foucault, does anyone remember Michel Foucault, famous crime and prison skeptic? He was scathing about prison reform and humanization. He scornfully stated that whether the prisoners get an extra chocolate bar at Christmas or let out at Easter is not the real issue. What we have to do is to denounce not so much the human side of life in prison, but rather the prison's real social function, which is to serve as an instrument that creates a criminal milieu that the ruling classes can control. He derided prison reform projects, but he didn't say anything specific himself, Professor Michel Foucault. He simply said, airily, there can be no reform of the prison without the search for a new society. Thank you, Michel Foucault. That doesn't help us in South Africa today. And of course, AdJASA's limitations do underscore its impetus. Are we merely a band-aid on a dysfunctional system? Do we merely legitimize the carceral project by forming part of the architecture of surveillance that produces docility in prisons? We offer reports that are couched in rights language, like the Correctional Services Act. And yet the system daily offends human rights. We are not, by offering our reports, do we envelop the system in human rights language? Unless our reports become binding officially, our human rights language creates the appearance of respect for rights without the obligation to enforce them. We are concerned enough to inspect, but do we press for real change? That's what keeps me awake at night. Now, call to action. I don't know if Prelisha's gone to a 10-month-old. I hope she has, but I don't know if the acting chair, I don't know if Professor Corder has taken over, but in the new Jim Crow, worth reading, it's where Professor Michelle Alexander makes provocative statements about what. Prelisha, you back?
Yes, no, I'm still here. I was going to.
Sleeping.
I'm about to leave. So I was waiting for the end of this until you handed over to questions. So I'm going to listen to the end, and
I need
thank you
another
again.
10 minutes for my 3 challenges.
Yes.
She says that mass incarceration categorizes a criminal justice issue which should be categorized as a racial justice or civil rights issue. And while in the US, as I've mentioned, there is significant intra-party consolidation of views that the evils of the 1990s mass incarceration, Bill Clinton and Senator Joe Biden helped put those through, that those should be renounced and revoked. We haven't had that debate yet. And my calls at UWC in 2018, at UCT in 2019 for abolition of minimum sentences didn't even provoke debate. That's why I've cornered all of you tonight. And I want to put challenges to you. 3 challenges. First, our parole system. It's overclogged, under-policed, inefficient and slow. Many of those entitled to parole are left waiting. At the same time, paradoxically, some terrible mistakes have been made, where released offenders quickly reoffend, on occasion murderously, similarly indicating the dysfunction of the parole system, because if the parole system had worked properly, they would not have been released. So while parole can be applied as a mechanism to reduce the number of sentenced offenders, DCS does not at present have the capacity to do so. This is highlighted by the question I mentioned earlier, the question of lifers. And in my paper, which is all here, and perhaps I can give it to Pralisha if you want to see it later, a lifer is now eligible under the CSA after serving only 25 years. You've got to serve a minimum. It used to be 13 years and 8 months. Before that, under the 1959 Act, you could get parole as a life sentence after 10 years. Now it's 25 years. So the Constitutional Court, at least in Pa'ahla, said that those who committed their offences before 2004 didn't have to suffer the consequences of the post-2004 amendments. But nevertheless, the processing of lifers raises serious questions about statutory validity and about administrative justice. And this is my first challenge to you, ladies and gentlemen, vrienden en collega's. The system has to offer, someone has asked me to share the report, my paper, and it'll be available. Justice Moseneke, my revered and treasured colleague in the court, the Deputy Chief Justice, told me that once the prison door clangs shut, the first thing you think of is, when am I going to get out? He didn't have any prospect before his 10-year sentence was up because of the cruel denial of parole to political prisoners under apartheid. But we offer parole, and the first thing every prisoner thinks about is parole. That's why the system has to work. Are there separation of powers concerns that only the minister can administer parole? I'm not certain of separation of powers concerns, but there is a statutory question there. Is it politically feasible to delegate the minister's functions? We are getting an influx of complaints from lifers. The minister's desk is littered with parole applications from lifers. And I've done a calculation in the paper. If he spends 10 minutes per application, 7 days a week, for 8 hours a day, it will take 4 years for him to process all those applications. The ministerial backlog appears to breach the efficient administration and good governance required both by PAJA and Section 237 of the Constitution, that requires the performance of constitutional obligations diligently and without delay. And of course, administrative consideration of someone's liberty amounts to a constitutional obligation. What can JICS do? Is it hamstrung? Can it hold an inquiry? Should we make inquiries and hold hearings? You can tell me what to do, ladies and gentlemen, friends, please. Second challenge, segregations. Our statute, grandly in 2008, excised solitary confinement, a shameful apartheid tool in the 1950s, and then, as I said, increasingly in the 1960s, and of course enormously in 1985 to 86, and from 1986 onwards under the emergency regulations. It said we no longer have solitary confinement, we only have segregation. Well, it's a sweeter word, but this is my challenge to the meeting tonight. First, the provisions creating the entitlement to segregate, the power to segregate, are extremely broad. When an inmate displays violence or is threatened with violence, he may be put in segregation for a very limited time, and then that segregation may be extended if the head of the prison, quote, believes that it is necessary. In my paper, I draw the contrast between that provision, section 30 sub 5, and section 32 101(2)b, 102(2)b, and 108c, where reasonableness precedes. Can it withstand constitutional challenge? I beg of you, please take up section 35. We know from Darwood that you cannot confer an unguided discretion. It's got to be clear, accessible, predictable, and with certain in manner. If the power to segregate is Darwood challengeable, what practical recourse will AdJASA take? A second feature is that there is an appeal. It's not called an appeal, it's called an appeal for mechanical restraints and for the use of force, but in effect it's an appeal. There's a statutory blip in the language. But if and decisions to segregate are clearly reviewable under PODJA, but what practical recourse does this offer to inmates? And is this watered down form of oversight accessible? So my first question is the statutory powers. My second question is the administrative powers conferred and whether they can be challenged. Scholars have pointed out, Professor Peterson, Mohammed, Munting, and Lorizzo, that the provision lacks all clarity. What does it mean that segregations can go to the inspecting judge? Are they suspended? How can the inspecting judge effectively deal with a challenge in the 72 hours that the statute allows him? My third question about segregations. Segregations is my second challenge to you. The first is bail, second challenge, segregation. My third question, do segregation practices at some centers violate domestic and international law? Waiting for one of you, ladies and gentlemen. International law prohibits indefinite solitary confinement and prolonged solitary confinement in excess of 15 days. Take Ebongweni Supermax down at Kokstad. According to our information, inmates are locked up for 23 hours a day for a minimum of 6 months on arrival. And we don't know who has the power. It's not clear who has the power to graduate them from this segregation after 6 months. It may be continued. We know that a large cadre of Ebongweni prisoners are still in solitary confinement, in segregation, after a year. So the Mandela rules prohibit this. And based on JICS's inspections and reports, correctional centers in South Africa may thus fall short of international law standards. I beg of you, ladies and gentlemen, on this call tonight to consider that. Last challenge, and in my conclusion, where are we? We're still going to have nearly 20 minutes for questions. I hope you have questions. I love questions. Bail, cash bail. The issue I raised with the minister, I gave him an opinion. Unfortunately, a very respected and valued former colleague of mine had given an opinion saying he couldn't do it under the emergency regulations. I gave a detailed opinion to the minister based on the reasoning in that opinion, indicating what powers he had. I said to the minister, you could decongest prisons by releasing 5,000 remand detainees. Remember, I told you there are 48,000 now, and that number went up under COVID because of all the COVID related. That's a separate topic. We should not have used securitization measures under COVID. We learned that lesson in AIDS, another public health pandemic, which put our lives and our our well-being at risk from contagion, a feared, stigmatized contagion. AIDS said, don't use coercive measures. COVID comes along, we beat up people in their front yards, we shoot people with rubber bullets, terrible mistake. And so people landed up in jail and couldn't afford the cash bail. It is intolerable, disproportionate, and unjust. We're waiting for a class action. Which of you, ladies and gentlemen, dames and heren, is going to bring it? That the cash bail system is intolerable, disproportionate, and unjust. If we perpetuate a system that detains people solely for their poverty, does it amount to a direct class or wealth-based discrimination or indirect discrimination? Because almost all of the people in prison who can't afford their bail are black. They are prisoners of poverty. May I just say that what I'm saying now is nothing new. My predecessor, Judge Hannes Fagan, the father of two very well-known lawyers, Edward and Anton, he said all of these things nearly 20 years ago. So we have recourse, we have the possibility to abolish the system of cash bail immediately and completely. During April 2020, California set a statewide emergency bail schedule that reduced bail to $0 for most misdemeanors and most low-level felony offenses. This led to a significant drop in California's COVID prison population. And Illinois just last week abolished cash bail. Governor Pritzker justly called this a substantial step towards dismantling the systemic racism that plagues our communities, our state, and our nation, and brings us closer to true safety, true fairness, and true justice. I embrace every single one of the governor of Illinois' words. Now I'm done. I've got just a final few words. I return to where I started, the intractable social and conceptual issues of crime, punishment, and prisons. For the harshness of our penal policies, we cannot blame a crime-weary, crime-ridden public. Their anger and fear are well warranted. We must blame ourselves, the academic and intellectual elite, the politicians, the lawyers, the judges, the thinkers and the leaders who've done nothing about this for the last 20 years. It's my fault. It's our fault. It's every one of our fault. Hence my urgent plea tonight to get involved. Let me finish by quoting Dr. Alex Boraine, co-chair with Archbishop Tutu of the TRC. He said, there may be many in our society who feel that we ought to be talking much more about crime and about victims rather than prisoners. That is very understandable. Nevertheless, it would be tragic in our society if the pendulum swings so far that we don't care about prisoners and about their protection. My submission, my last words, are that that pendulum has swung far too far and that we have to swing it back. Thank you very much.
Thank you, Justice Cameron. I'm assuming that even though Pralisha is still on the call, that I should take over now. You may be if my own reaction to what you've just told us is anything to go by, you may not get any questions because I'm stunned into silence. But I'm acting as the chair, and I'm delighted to be here to do so. I'll reserve my formal thanks to the conclusion of the proceedings, but I now do throw it open. Please will people indicate by raising their hands on the device on the screen, and I'll give you the opportunity to, and I would encourage you, please, to respond to the triple challenge at the end of Justice Cameron's lecture or any other thing that he said. Let me pause now to see if there are responses.
Silence is consent, Hugh.
Yes, no, Edwin. But then let me say, as the chair sometimes does, what kind of responses have you had? I am sure that you've been making similar pleas to different audiences over the last 14, 18 months since you've been in office. And one has read in the media and on legal briefs and whatever of other utterances similar to these. Do you feel that your words have been falling on deaf ears, and maybe there's a link or an entree that you can point those present, whom I'm sure all bunk fuss behind your words, your arguments, and your sentiments?
Let me answer you, Hugh. I went to Makado on Tuesday, which is 450 kilometers north of Johannesburg, the old Louis Trichardt, and I spoke to the area commissioner there and to the independent visitors that JIX employs to visit each and every prison in the country. And the prison's officials are grateful for JIX, they're grateful for its scrutiny, because they are also the victims of this wickedly misprescribed war on crime. So I have support from prisons officials who, the dilemma of the lifers was first drawn to my attention by prisons officials. So I think we're making an impact. We've got a ripeness to move. I would say, however, that we have to build it up through crime intelligence. The most important thing, in my view, is an efficient crime intelligence. Look at the horrific, shameful farce that crime intelligence has become over the last 10, 12 years. If you have efficient crime intelligence, you can deal not just with syndicalized crimes, you can deal with corruption within the police, within political life, but you can deal with crimes like stealing manhole covers, because you find out where they're selling them, and you go and nab the scrap metal dealer. So crime intelligence, NPA are essential components of rebuilding a functioning crime strategy. I'm not an institutional builder, I'm an institutional commentator, but I would support an institution building response. But in the meantime, what we can do immediately without first fixing crime intelligence, decriminalize drugs immediately. You will release several thousand prisoners. Take away minimum sentences from, I've got the list in my paper: fraud, extortion, forgery, uttering. Do you know what uttering is, you? I once had a case 30 years ago about uttering. It's when you put forward a false note, a forged banknote. So we can do that immediately and decongest our jails. And I urge that most strongly, and I'll continue urging it. And I think it's ready. I will tell parliamentarians that. I've said much of what I've said when I've spoken to the parliamentary committee. They're also receptive, but we need action. Mm.
Certainly, what you've done tonight, and I'll just conclude this and then give ME a chance. That's probably Mike Evans. But the raising of consciousness is an incredibly important thing in wider society, and the work of NGOs who focus on this area is something that could be supported, as well as litigation, as you've indicated. Is ME Mike Evans? If it is so, please go ahead.
Yeah, thanks, Hugh. I was going to pick up on exactly the issue you've just highlighted. I mean, these types of changes in policy in the past have often required civil society action rather than government action. I'm thinking of the AIDS challenge, where the TAC played the major role in bringing about change in policy in relation to HIV/AIDS. Now, I mean, there was a while back when you constantly heard about Golden Miles Budu and what he was doing in relation to the prisoners. But I haven't heard of any organization or any civil society organization that is focused on the sorts of issues you're raising. And I would have thought that for the type of changes you're talking about, it would require a kind of multi-pronged challenge, both litigious government level, but then also at a civil society level. And are you aware of civil society organizations that have taken this up in the same way as we've had, taking up environmental issues and really bringing about change, or taking up health issues and bringing about change?
Very definitely, Mike, and thank you for that question. You and I were complicit in the 1980s in trying to keep conscientious and religious objectors out of jail, Mike, and it's lovely to see you here. Yes, there's UWC, the African Criminal Justice Reform Initiative under Professor Munting, who's an expert on prisons. There's the Detention Justice Forum, Just Detention International. I'm going to err here by not mentioning some very Wits Justice Project. There are very good civil society organizations. What we need to do is, I think, to have a strategy session where we select important initiatives to challenge the constitutionality, perhaps, of minimum sentences, or certain kinds of minimum sentences, which may be a difficult task to do, but to take some actions, including those that I've outlined in my address tonight. So there are thoughtful community and civil society sector organizations. And Mike, can I just say, will you please retract your implication that Mr. Golden Miles Budo is no longer active? He is. He's in my inbox every day. And Deputy Minister Nkosi Patakila Holomisa gave him my private cell phone number. So I draw a veil over everything that happens from there. But I'm going to give him, Mike, I think I've got your cell phone number. I'm going to give it to Mr. Golden Miles Budo so that he can phone you.
Thank you, Justice Cameron. I see Professor Gio Quino from Stellenbosch University would like to speak. Gio, please go ahead.
Hello, Gio.
Thank you very much, Justice Cameron. Thank you for your excellent presentation. So I think there's another angle to this that requires attention, and where I think administrative lawyers should really be involved. And I think that's on the design end of regulatory regimes, because I think I've often noticed that there's this kind of knee-jerk reaction to criminalize anything that people in new regulatory regimes do not want to happen. And I think unless we start to really work on proper legislative drafting principles, which must include staying away from criminalization where it's absolutely not necessary, we're not going to see a reduction of that kind of knee-jerk reaction. So I was wondering, I mean, one of the things that I've really been thinking about since, under COVID, we've seen so much new regulation, whether you've got any thoughts about how one could go about starting to just get some coordination at that regulatory making level. Because it seems to me that, we are making laws in South Africa and regulations all over the place, and there's absolutely no coordination. There are very, very few principles that can guide whoever are drafting these things. And I think that might be another important strategic intervention to avoid the problem in terms of, starting off in creating new regulatory criminalizations in regulatory regimes. Thank you very much.
I fully agree with what Professor Quino says, and thank you for raising that point. You're absolutely right. And of course, the most tragic example of unnecessary criminalization, misdirected criminalization, was the COVID regulations, where we needed a public health approach, an exampled approach, an exemplary approach, a persuasive, informative approach, instead of which we brutalized too many people. And we filled, when I went to the awaiting trial section of Johannesburg prison, the notorious Sun City, last May, I was told that their awaiting trial overload had increased by 10%. And I saw certain cells in which there were 90 people, cells designed for 22 people. But it's an illustration of the point you're making, that we've got a terrible national disaster. We are really scared. We've got to stop people. We've got to tell them to wear masks and to observe the curfew, but we shouldn't be criminalizing it. It's counterproductive. To put those people in jail, put them at greater risk of COVID, just from a public health point of view, let alone a rights point of view.
Thank you. We've got a moment for one further question or comment. Peter, please go ahead. Is Peter Vormink? Yeah.
How are you, Peter?
I just had to unmute. Thanks very much. And good evening to you, Edwin. Thanks for a very compelling and a very strong argument that you have put forward in all these three areas, the parole system, the question of segregation, bail, etc. If you go down to the local magistrates court today, the number of people who are remanded in custody because they don't have any fixed address, allegedly, is astounding.
Yes.
And I have a strong suspicion that they do in fact have a fixed abode. It may not be a house with a number in a tree-lined street, but they have a place to stay. And the IO very often goes to court and tells the prosecutor, we can't find any fixed abode for this person, and off this person gets shipped back to the cells. But as I listened to you, and as much as I felt that your talk was a compelling one, and you put forward a compelling argument, I would like to raise perhaps a non-legal consideration. And that is, how do you win this argument in the court of public opinion? And it is a difficult one for me to get a clear answer to. I think that everything that you have said has made perfect sense, I'm sure, to everyone in this engagement. But the broader court of public opinion would probably be quite, what is the correct word? Perhaps unreceptive. Let me use a polite word, and say that they really, would not want to entertain any further relaxation, and the normal argument, our lives are in danger, etc. And I think it is important to pursue human rights values without devaluing or minimizing the voice of public opinion. I'm not for one moment suggesting that should trump constitutional values. No, but I do believe there should be some sort of engagement with that aspect, so that our arguments don't just make sense legally or politically, but also socially.
Yeah,
I agree with the point.
Thanks, Peter.
And can I make it this way? It is a long process. We've got to start with what we can do immediately. We've got to abolish drug offences. We've got to abolish the minimum sentences on those non-violent crimes. We've got to release people who are granted bail but can't afford it. What I have said in the past is that we are so busy with crime. We are so busy trying not to drown that we're not stopping to learn how to swim. So I agree with you, it's a complex thing. I go on to radio talk shows. I'm immensely respectful of people who've lost loved ones. You know people who have. When I talk to groups, I ask people, how many of you have suffered from crime? 60% of people put up their hands. How many have suffered from violent crime? 40% of people put up their hands. I say, how many of you have suffered from violent crime in your own homes? Sometimes it's 1/3 of people. So I appreciate what you're saying, Peter. You're right. I don't have all the answers, but we can start somewhere. And I wasn't asking for an instant prescription. Let us start somewhere. Mike Evans has got it right. We've got to activate a civil society initiative that can work with lawmakers, that can work with correctional officials who realize the futility of these policies and can design better policies at the same time as getting crime intelligence and the NPA working again. We can do it, Peter. My concluding comment, you, and I know you want to finish this, is that under AIDS, we have a president who was a denialist, a minister who said that black people couldn't tell the time and wouldn't be able to take ARVs. We've now got the world's biggest publicly provided ARV program. 5 million people like me owe their lives today to ARVs. So there's nothing we can't do if we set our minds to it as South Africans. Thank you.
Thank you, Justice Cameron, Edwin, for ending us on that note. As he was speaking, as Peter was speaking, I was thinking that if the Court of Public Opinion had ruled, we would still have the death penalty. We would still be executing hundreds of people a year. I also, the thought occurred to me that one sometimes is blinded by, almost blinded, standing in the headlights by the enormity of the problem. And it's to chip away, to take a small initiative that may have a limited effect and gradually to build momentum or something like that. Justice Cameron, with your typical verve, passion, incredible articulate presentation of your paper, and I know that all of us will benefit from further engagement with it and distribution of it among our colleagues and friends. I think it's a matter of raising consciousness and then acting, not only raising consciousness. So thank you enormously for the time that went into writing the paper, for your time this evening, and colleagues and members of AdJASA, thank you very much for staying on after our regional general meeting. It has been a riveting hour that we've had in your presence. So enormous thanks to you. Good night to all. Keep safe and take care. Thank you.
Thank you.
Thank you very much.